If it pleases the court, my name is Peckham, initial M, and I'm here with my learned junior counsel, McCartney, initial C, for the defendant, Juniper Eatery, in this matter. Your Honour, the defendant will present the following submissions in response to the plaintiff's claims. I will address submissions 1 and 2, and my learned junior counsel will address submissions 3 and 4. If it pleases the court, I will now turn to my first submission. Your Honour, the defendant accepts as a licensee the Juniper Point Eatery owed a duty of care to the plaintiff, who was a patron of the JPE on the 5th of August 2017. The defendant also accepts that the duty owed to the plaintiff was to ensure that the premises were safe and to take reasonable measures to control rowdy and intoxicated patrons from criminally injuring the plaintiff. The duty of care owed by a licensee to its patrons is a well-established category and recognised relationship in the common law. However, the defendant argues that the scope of the duty is not absolute and did not extend to monitoring the offender or the plaintiff after leaving the premises on the 5th of August 2017. In the High Court decision of Wagstaff v Haslam at 724, the basis of liability lies in the control exercised by the occupier over patrons and the occupier's knowledge of the ability to know about the intoxicated conditions of the patrons. The element of control is subject to statutory obligations not to permit intoxication or violent or quarrelsome conduct on licensed premises and to remove those who engage such conduct. In the present case, at the time of the incident, the statutory obligation imposed on the defendant was under Section 125, subsection 1B of the Liquor Act 1992 in Queensland. Your Honour, on the night of the 5th of August 2017, the defendant contemplated before the cafe opened from prior experience what was likely to prevail that night and understood the duty of care owed to his patrons. Later in the evening, the defendant was aware that the offender had been drinking and was presumably intoxicated. However, the defendant had no prior knowledge of the aggressive character of the offender, whether he was intoxicated or not. In Adil's Palace v Mulbrek 2009 at 26, the judge stated that the duty is not absolute. It is a duty to take reasonable care. It is not a duty incapable of performance. It is a duty the performance of which is supported by the provisions of statutory power to prevent the entry to premises and to remove persons from the premises, if needed, by using reasonable force. Although it is a duty directed to controlling the conduct of others for the avoidance of injuring other patients, it is a duty to take reasonable care in the conduct of activities on licensed premises, particularly with regards to allowing persons to enter or to remain on those premises. The defendant did the above actions and removed the offenders from the premises and ensured that they were safe. This, Your Honour, is where the duty of care to the plaintiff stopped. For the scope of the duty to include further monitoring of the behaviour and preventing the criminal conduct and associated injuries after the patrons had left the premises, the risk must have been reasonably foreseeable. The question is how you bestow a duty on a licensee to continue monitoring patients once they have left the licensed premises and had no prior knowledge of the aggressive character of those patrons. The duty is said to be coextensive with, although not identical to, the duty formulated in Adil's Palace v Maverick at 25, and does not extend to the vicinity of the licensed premises, in the particular case the car park, and should not be extended to monitor the patrons beyond leaving the premises. It is so the defendant would have required actual or constructive knowledge of the offender's aggressive character at the time of the incident for the risk to be foreseeable, and in this case he did not. Therefore, the risk was not foreseeable. If it pleases the court, I will turn to my second submission, standard of care. Your Honour, we submit that the defendant did not breach their duty owed to the plaintiff because the provisions of security guards at the event was not considered as a reasonable measure in the response to the probability of harming occurring as per Section 9 of the Civil Liabilities Act 2003 in Queensland. Your Honour, it may be accepted for the purpose of argument that there was a risk, of which the defendant knew or ought to have known, that there would be torturous conduct at the cafe on the night in question. It may be accepted that the risk of harm was not insignificant. The question that then arises is closely related to the question presented in Adil's Palace v Maverick 2009 at 40. Would a reasonable person in the position of the defendant have taken the precautions that the plaintiff alleged should have taken? Those precautions were to provide the security guards. The question can be answered by establishing the standard of care owed to the plaintiff. Adil's Palace v Mulbrek 2009 at 40 clearly states, when establishing a standard of care, the steps a reasonable person should have taken in response to a foreseeable risk of injury is to be examined prospectively and not retrospectively, and not with the benefit of hindsight. The 8 years that JPE have been operating and frequently held events of similar nature, there has been no prior history of violent incidences or altercations. Predominantly families, groups of friends and young people will attend these events. To hire security guards as suggested by the plaintiff would be seen as an extreme measure, not a reasonable precaution if you're looking at situations prospectively. The defence questions whether the plaintiff would have requested the provision of security guards if the incident hadn't had happened, and without the benefit of hindsight. The defence relies on the decision held by the High Court in Adele's Palace v Murray 2009 at 35. The licensee could not reasonably foresee the violence of the nature similar to this case would erupt in or around the cafe. Given the number and non-violent types of persons expected to be in attendance at the function, and because there was no history of violence that demonstrated a need for security personnel. Alternatively, JP does take reasonable precautions to hire security guards during private functions, as the likelihood of violent incidents occurring is foreseeable due to the number of attendees, the types of events, and the types of persons attending these functions. Your Honour, the defendant has demonstrated they took all reasonable precautions to ensure the safety of their patrons, including the plaintiff on that night. The presence of security guards was certainly not required, as the risk of harm was not foreseeable. Your Honour, my learned junior counsel will now proceed with submissions 3 and 4.